Good morning, students. Say your prayer. Thank you. நான் ஒரு நல்லாசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் மிருதுமொழியாக அன்போடு கல்வியை போதிப்பேன். நான் ஒரு நல்லாசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் மிருதுமொழியாக அன்போடு கல்வியை போதிப்பேன். நான் ஒரு நல்லாசிரியர். நான் உங்களுக்கு தாயாகவும் தந்தையாகவும் மிருதுமொழியாக அன்போடு கல்வியை போதிப்பேன். Okay, students, take your social science book. Take page number 241. Today we will discuss writs in the Indian Constitution. So writs, so it is nothing but issued in the court. So whenever an individual didn't get, so seek redressal, that is seek compensation for not getting any fundamental right, means he can move to court. So then the court issue a writ. Okay, so how the court issue writ? So what are the kinds of writ? We will discuss in this lesson, and also we will discuss about the directive principles of state policy. Previous class. So what we have discussed? Yeah, we discussed about fundamental rights. So how many fundamental rights are there in our Indian Constitution at present? Yeah, 6. Then in which part? Then which article mention about the fundamental rights? Yeah, part 3. Then from article 12 to 35. So list out the fundamental rights one by one. Yeah, right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, then right to constitution remedies. Okay, so we discussed these 6 fundamental rights in our previous class in detail. Okay, in this class we will discuss about the last one, right to constitutional remedies, further detailing. Okay, so in further detail we will discuss the right to constitutional remedies, that is in what way you can seek redressal, that is in which way the court issue the order for the compensation if a person didn't get or didn't enjoy any of those mentioned fundamental rights. Okay, so let us move into the lesson. So nothing but writ. Writ is an order or command issued by a court in writing under its seal. Okay, so writ is nothing but an order or a command which was issued by a court. So it should be issued by a court in writing under its seal. So under its seal, in writing, a command or an order issued by a court. So the nature of a command or prohibition from performing certain acts that are specified in the orders of the court. So these are the nature of command, so or prohibition from performing certain act. That is, it may be a command or prohibition. That is, it may be a command to do a work or prohibition from doing a work. So which are specified in the orders of the court. Then who can issue writ? Only the Supreme Court and the High Court can issue writs. Okay, so no other court. So there are district courts, there are magistrate courts like that and all, but the writ can be issued only by the Supreme Court and the High Court only. So they are only empowered, they have the power to issue the writs. So there are 5 kind of writs. Yeah, since the Supreme Court so is called as the guardian of the constitution, that means so Supreme Court is the highest court in India. Okay, if the person moves to the Supreme Court directly, means so the Supreme Court can issue writ, so which cannot be opposed by any other court in India. Okay, and also if there is any violation, in constitution, means that is if a person didn't get any fundamental right, means he can go directly to the Supreme Court. Okay, so if the order issued by the Supreme Court, then it was not opposed by, then there is no opposition from any other court in India. So that's why it was called the guardian of the constitution. Okay, so if there is any problems, if there is any situation arises against the constitution, means the Supreme Court came there and protect the constitution through his order, okay, through an order or a writ. So that's why Supreme Court was called as the guardian of the constitution. So Dr. B.R. Ambedkar mentioned that Article 32 is the heart and soul of the constitution. So because it only protects the, so this article only protects the fundamental rights of Indian citizen. So Article 32, that is right to constitutional remedies, only protects the fundamental rights of the Indian citizen. So that's why he called Article 32 is the heart and soul of the constitution. That is the heart and soul of the constitution, so lies in Article 32. So there are 5 kind of writs. So do you know what are they? Yeah, habeas corpus, mandamus, prohibition, certiorari, quo warranto. So there are 5 kind of writs. So who can issue the writs? Yeah, only the Supreme Court and High Court. Yeah, so there are 5 kind of writs. So they are habeas corpus, mandamus, prohibition, certiorari, then quo warranto. Habeas corpus. So habeas corpus, so it safeguards the people from illegal arrest. If any person was illegally arrested by the police department, means it ordered the police to produce the person. Okay, so habeas corpus safeguards the people from illegal arrest. So illegal means so against law. So if a police wanted to arrest a person, means so they have to get permission from proper appropriate authority. So if they arrested a person without legal, so without any permission from the authority, means so the court order the police department to produce the persons in front of them. Okay, so the habeas corpus means so safeguards the people from illegal arrest. That is, it order the police department to bring the imprisoned individual to the court and show the validation for his detentions. Okay, so the court ordered the police to bring the person so in before the court and asked the proper reason for his arrest. Okay, so habeas corpus means so nothing but produce the body. So that is produce the individual in front of the court. Then mandamus. So it protects the petitioner who requires legal help to get his work done by respective public authority. So mandamus means so it protects the petitioner. So petitioner means so who put petition, that is who request the court for a change. So who request for a change. So it protects the petitioner who requires legal help to get his work done by respective public authorities. So that means if a public authority didn't do his official duty correctly, means then the petitioner will file a writ case in the court. Then the court issue an order to the public authority to do his work properly. Okay, so that means a writ is nothing but a court order commanding an inferior court or public authority to perform his official duty correctly. That is, if a government officer or an inferior court, so that is the court which was under the High Court or Supreme Court, if they didn't do their duty properly, means so then the court issue an order to do their work correctly. So that is called as mandamus. Then prohibition. It prohibits a subordinate court from acting beyond its jurisdiction. Yeah, so the prohibition means it prohibits a subordinate court from acting beyond its jurisdiction. So jurisdiction means so for every court there is a limit. So there is a boundary. So there is a particular limit. Okay, so say for example Madras High Court. So the Madras High Court can issue order so only to its limit. So only the cases that held in Tamil Nadu. Okay, so the cases that happened in Tamil Nadu, then the Madras High Court can take that cases and issue order. Yeah, if it is beyond its jurisdiction, means if the case that took place in Kerala or Karnataka, Andhra, means then the case should be taken only by the respective high courts only, so not by Madras High Court. Yeah, so if Madras High Court takes such cases, means so the Supreme Court so issues an order to stop it. Okay, So prohibition means it prohibits a subordinate court from acting beyond its jurisdiction. Certiorari, it quashes an order, that is, it cancels an order issued by a subordinate court by overstepping its jurisdiction. So suppose if a court issue an order beyond its jurisdiction means then the High Court or Supreme Court so cancel its order. Okay, va? So already we saw. So prohibition means so nothing but it prohibits a subordinate court from acting beyond its jurisdiction. So it prohibits an subordinate court from acting beyond its jurisdiction. Suppose if a court act beyond its jurisdiction means then the higher court issue an order by cancelling it. Yes, High Court or Supreme Court quashes an order issued by the subordinate court by when it overstepping its jurisdiction. Okay, so writ of certiorari is an order by the court directing the lower court to send up the records in given case for its review. Okay, so to cancel this order. So the High Court asks the records to send, and by analyzing the record it can cancel the order issued by the lower court. Then fifth one, quo warranto. So quo warranto means what is your authority? That means if the government or the public office misuse their power means then the court issue this writ. So this issue this order quo warranto. That is the court inquires into the legality of claim to public office. Okay, so the main object is to prevent the usurpation of public office, that is misuse of power by the public office. So when a public officer misuse his power, so misuse his power beyond his limit means then the court can issue this writ. So the court can issue the order in what authority. So what was your power to issue such order? Okay, so when was this type of writ issued means whenever a person was appointed when he is no proper qualification. So when a disqualified person is appointed for a post, then if procedure was not followed, okay, so if there is a procedure so for us not followed in any department, so that is the proper procedure was not followed in any department, then if a person is appointed irregularly, okay, so if there is any irregular appointment in any department means then the court issue this order. Quo warranto means see in what qualification a person was appointed. It asks the qualification for a person in appointing various department. See in appointing for the post. Okay, so quo warranto means the court asked the qualification of a person in appointing any department, in appointing a post in any department. So we discussed 5 writs. So this slide discussed all the 5 writs. Okay, so name the writs, the 5 kinds of writ. Yeah, habeas corpus, mandamus, certiorari, prohibition, quo warranto. So first habeas corpus means you may have the body. So literally it means you may have the body. It is the main purpose is to release a person who has been detained unlawfully, whether in prison or in private custody. That is, it safeguards the people from illegal arrest. Then mandamus. Mandamus means literally it means we command. So that is to secure the performance of public duties by a lower court, tribunal or public authority. Then certiorari, to be certified, that is to quash the order, that is to cancel the order already passed by an inferior court, tribunal or quasi judicial authority. Certiorari means to be certified, that is to cancel the order. Then prohibition means so to prohibit or stop, that is it to stop the inferior court from acting beyond its jurisdiction. So to stop the court from acting beyond its jurisdiction, so beyond its limit. Then quo warranto means what is your authority, that is what is your power, what is your qualification. Okay, so it cancel or it stop the person, that is it stop the action of the public person when he act beyond his power. So whenever a person, public officer act beyond its power means then the court, High Court or Supreme Court issues this writ, quo warranto. Okay, so there are these are the 5 kind of writs: habeas corpus, mandamus, certiorari, prohibition, quo warranto. Okay, list out the five writs. Yeah, habeas corpus, mandamus, prohibition, certiorari, quo warranto. Yeah, so if an Indian citizen was prohibited from getting any fundamental right means, then he can move to the court. Yeah, so then the court, Supreme Court or High Court, can issue the order for the person to enjoy his fundamental rights. So now, so when can be fundamental rights suspended? Is there any chance for suspending the fundamental rights? Yeah, the fundamental rights can be suspended only by the president through his order. Yeah, so the fundamental rights can be suspended by the president only. Okay, so when the president makes a proclamation of emergency under Article 352, that is, when the president issues national emergency means, then the freedom guaranteed under Article 19 was automatically suspended. Okay, so whenever the president issue national emergency under Article 352 means, so then the freedom guaranteed under Article 19 were suspended. So we will discuss the Article 352, that is national emergency, in our upcoming, in our next classes. Okay, so what are the freedoms guaranteed by Article 19? Can you recall? That is the 6 type of freedoms. So that is freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence, and freedom of profession. That is freedom of trade. Okay. So these are the 6 fundamental rights. So that are suspended automatically when the president issues the national emergency. So the president can suspend other fundamental rights through the specific orders. Okay, so he can suspend the other fundamental rights only through special orders, but these orders must be approved by the parliament. Okay, so whenever the president issues the order of cancelling the fundamental right means, so that should be approved by the parliament. That is by both the Lok Sabha and Rajya Sabha. Then directive principles of state policy. So directive principles of state policy. It is nothing but the principles that should be followed by the state or by the government whenever they are planning their policy. Okay, so the principles that should be kept in mind by the state or a government whenever they decide their policy. Okay, so these are mentioned in part 4 of the Constitution and from Article 36 to 51. Yeah, so the directive principles are mentioned in part 4 of the Constitution from Article 36 to 51. Yeah. So this Constitution, the Constitution does not contain any classification of directive principles. So there is no classification. Okay, so the directive principles of state policy have no classification. But based on their content and direction, they can be classified into 3 categories. So the directive principles of state policy, so based on their content and direction, can be classified into 3 broad categories. That is socialistic principle, Gandhian principle, then liberal and intellectual principle. Okay, so socialistic principle, Gandhian principle, and liberal and intellectual principle. Yeah, so these principles are not enforceable by the court. Yeah, that means these principles was not enforceable. That means, so no court, so that is Supreme Court or High Court, can issue order. So they have no power to issue order to the state or the government to maintain this principle. Okay, so it is, that means it is not legal, it is not a fundamental one. So the rights which should be enjoyed by the person through an order may be considered as the fundamental rights. Yeah. So then the rights which should not be enjoyed by a person through the order of the court is considered the directive principle of state policy. So they are legal in nature. Fundamentals are legal in nature, while the directive principles of state policy was not legal in nature. So that's why they say they are not enforceable. That is, the court cannot issue order to the government or the state to follow the directive principles of state policy. So they are not enforceable by the court. Yeah. But these principles are basic for the governance of the country. So though the court have not power to issue writs or issue order for the directive principles of state policy. So they are fundamental, they are basic for the governance of the country. Okay, so that's why Dr. B.R. Ambedkar described these principles as the novel features of the Indian Constitution. Okay, so because they aim at promoting the social welfare of the people. Okay, so the directive principles of state policy aimed at promoting the social welfare of the people. So that's why Dr. B.R. Ambedkar, okay, so who was the father of Indian Constitution, described these directive principles of state policy as the novel features of Indian Constitution. Okay, so any doubt in this directive principles of state policy? So it was mentioned in part 4 from article 36 to 51. Then this was divided into 3 categories. Okay, so based on the content and direction, it can be classified into 3 types. So what are they? Yeah, socialistic principle, Gandhian principle, and liberal and intellectual principle. Okay, but they were not enforceable by the court. Okay, but they are fundamental, they are basic for the governance of the country. Okay, then how was this directive principle of state policy was described by Dr. B.R. Ambedkar? Yeah, novel future. So no doubt. So if you have any doubt, just contact me. So today we will discuss about the right to constitutional remedies, writs. So the 5 kind of writs, then the directive principles of state policy. Okay, in tomorrow's class we will discuss about the fundamental duties. So you enjoyed your fundamental rights, but you have to know your duty now. Tomorrow's class we will discuss the fundamental duties in detail. Thank you. So do your homework. So today's homework was write the 5 writs. Okay, so write the 5 writs. That is the habeas corpus, mandamus, prohibition, certiorari, quo warranto. Yeah, so write those 5 writs with its explanation. Okay, so that is your homework today. Then for textbook reading, read the difference between the fundamental rights and directive principles of state policy. Okay, so read the difference between directive principles of state policy and fundamental rights. So the difference. Okay, so thank you. Have a nice day.